Good morning. This is Rajeshkumar. Today we are going to discuss a theory question on economic duress. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. That's not a theory question. The doctrine of economic duress is a very valuable doctrine to control corrosive behavior when the parties are modifying the existing contracts. Discuss. The doctrine of economic duress serves as a crucial mechanism for addressing corrosive behavior in the modification of contracts, providing a means to counteract illegitimate pressure and thus ensure the voluntary consent. Economic duress has evolved from the broader doctrine of duress and undue influence with the key cases helping to shape its application, especially concerning the contract modification. The doctrine of economic duress emerged as a means to address the situation where one party applies the illegitimate pressure on another to modify an existing contract. Initially, the contract law did not recognize economic duress, focusing on physical threat or personal duress. However, as the commercial relationship became complex, English courts recognized that financial threat could also undermine the contractual freedom. In the Sibon and Sibotri case in 1976, economic duress was acknowledged for the first time, setting a precedent that financial pressure could void the contract modification if it deprived a party of genuine consent. However, this case did not establish a clear criteria which came later through judicial developments. Let's see the key requirements of economic duress. The economic duress in contract modification requires illegitimate pressure. The pressure exerted must be more that than had a bargaining. It must be unlawful or against the reasonable commercial norms and the lack of consent. The pressure must leave the aggrieved party with no reasonable alternative but to agree to the modification. Causation. The pressure must be significant, the cause of the contract modification. Let's move on to the how the economic duress is being evolved. As we dealt early, the Sibon versus Siboche case introduced the economic duress, recognizing that the financial threats could vitiate a consent. However, it stopped short of outlining the specific criteria. Whereas in the Baron case in 1979, the case evolved a shipbuilding contract where the plaintiff was pressured to accept a price increase due to the currency fluctuations. Here, the court highlighted the requirement of illegitimate pressure, but it did not find duress as the plaintiff delayed in seeking redress. In Pawn and Lying case in 1980, the Privacy Council outlined the elements of economic duress, emphasizing that the threat must leave the claimant with no reasonable alternative. This case also stressed the importance of immediate action in response to, the duress. Whereas in the Pakistan Airlines versus a Times Travel case in 2021, this recent Supreme Court decision clarified that legitimate commercial pressure is not duress unless it is unlawful. The court held that the economic duress recurs an unlawful threat or illegitimate pressure, and merely leveraging a strong bargaining position does not constitute the economic duress. Economic duress in the context of contract modification. Economic duress is particularly valuable in contract modification context because it provides a remedy for the parties caused into agreeing to unfavorable terms under illegitimate threats. Unlike the contract formation, where both parties enter the negotiation freely, modification often occur under constrained conditions, where one party might exploit the other's financial vulnerability. Is this doctrine still valuable? The doctrine is indeed valuable as it safeguards fair dealings in contractual modifications, ensuring that no party can be forced into agreeing to the terms under the threats that undermine their freedom. It holds businesses accountable for abusive practices and helps maintain the equitable standard in commerce. The doctrine, however, is limited in scope as courts require a clear demonstration of illegitimacy and causation, as seen in the Pakistan Airlines versus Time Travel case. This ensures that economic duress is not over applied in cases of tough but legitimate commercial negotiations. Requirements. The economic duress emerged as an extension of a traditional duress doctrine, adapting to cases where illegitimate pressure rather than the physical corrosion compromises a party decision making. As established in Sibon versus Sibocha case, the concept introduced the possibility that economic or the commercial pressure could vegetate the consent, providing the pressure significantly constrained the will of the affected party and deprived them of practical alternatives. Later, cases refined this by establishing criteria for economic duress. The pressure must be illegitimate and it must be the primary factor inducing the contract change. Notably, in the Atlantic Warrant case in 1979, the court recognized that economic pressure in the form of unlawful threat to breach an existing contract could constitute a duress if it coerced the other party into compliance. However, the president also highlighted that the affirmation of a contract over the time could waive the claims of duress. Let's move on to the specific context of contract modification. The doctrine, application in contract modification rather than the contract formation, provides a distinct context in which the economic duress become especially the relevant. The ability to renegotiate under the duress highlights the vulnerability of a party seeking to adjust the contract terms under financial or situational constraints. In Power On versus Love in Long case in 1980, the Privacy Council clarified that the commercial pressure alone does not suffice to establish the duress. Rather, a corrosive element that overbears the will of the pressured party must be present. This emphasized that not all hard bargaining is corrosive. The economic duress is applicable only when the pressure is so severe that it removes the genuine consent. Let's move on to the modern reaffirmations and the limitations of economic duress. The recent case, as we have discussed earlier, the Pakistan Airlines versus time travel, solidified the importance of this doctrine, but also recognized the limitations in applying the economic duress to the commercial bargaining scenarios. The Supreme Court clarified that lawful but morally dubious actions generally do not meet the threshold of economic duress. Here, the court stressed the importance of evaluating both the nature of the pressure and the demand it supports, which may not always translate to duress in purely commercial dealings. Let's discuss the final topic of the valuable nature of the doctrine. The value of economic duress lies in its ability to provide redress. When one party, leveraging the significant power imbalance to cause on agreement modification, ensuring that consent remains central to the contractual obligations. It acts as a corrective in scenarios where negotiations may otherwise exploit vulnerabilities, as seen in the Atlantic Baron case, where a party threats to abandon a contract amid the severe financial pressure led to an actionable duress claim. However, economic duress remains challenging to prove due to the requirement that the pressure be illegitimate and substantial enough to overbear a party's free will. To conclude, the economic duress serves as a protective measure in contract modification, safeguarding against unjust corrosive practices. It is a valuable doctrine that encourages fair dealings in the renegotiation of contracts, though its limitations also prevent it from undermining legitimate business pressures. Further, economic duress serve as an essential check on the corrosive behavior in contract modification, allowing the court to invalidate the modification obtained through illegitimate pressure. However, the doctrine also respects the sanctity of contracts by upholding the modifications made under legitimate commercial pressure, thereby balancing the freedom of contract with protection from exploitation. Thank you.